and is not able to be with us. But fortunately, Mr. McGarva, who worked intensely with Mr. Shibley in the preparation of the paper that Mr. Shibley was about to give, is available to us, and we'll give that paper. Now, so that you know something about Mr. McGarva, he graduated from Harvard University in 1975, magna cum laude in government. He's a fellow of the John F. Kennedy Institute of Politics. He graduated from the University of Toronto Law School in 1978 with honors. He called to the bar in 1980, and he actively participates in the practice of law in this province with the firm of Shibley, Wrighton, and McCutcheon. And we are very fortunate to have him with us today. No doubt he did most of the work in any of them.
Sure.
Thank you very much. I find myself sandwiched between Morris Manning and coffee, which is a no man's land between the tasteful and the tasteless. Over the past several decades, governments have played an increasing role in our lives. They educate our youth, they regulate our businesses, they monitor what we eat, they monitor the drugs we take. From time to time, they respond to public emergencies, and from time to time, they seize the assets of our bodies corporate. Now, it's against this backdrop of increasing government intervention in our society that the issue of negligence of public authorities has become an increasingly important one over the past years. I'd like to tell you a little bit today about the role that the common law has played in supplementing and contributing to the immunity of public authorities in actions founded in negligence. Now, having said that, I should warn you that the lecture will not deal with procedural limitations to actions against public authorities. That is a topic which has been canvassed elsewhere and in detail and very well, and I can recommend as a starting point Sidney Goldenberg's lecture here 10 years ago for issues of procedure. Nor do I intend today to deal with substantive limitations in respect of actions against public authorities which may be found in individual statutes. I'm not aware that there has been a compilation of those limitations anywhere done, but I suspect that with the burgeoning RSOs of 1980, that would be a monumental task even for Ontario. So I'm going to deal strictly with the common law and look at how the common law has supplemented the immunity of public authorities. I was hopeful to be able to bring to you today news of trends and directions in this field, an analysis of recent jurisprudence in Ontario, elsewhere in Canada, in the United States, and in England has not permitted me to isolate trends and directions. Rather, what I find is a gradual ebb and flow, a steady expansion and retreat of the limits of liability of public authorities, of the limits of the immunity of public authorities at common law. However, in seeking out those directions and trends, we have come upon a storehouse of judicial techniques and methods which are used in approaching cases involving public authority liability, and I'll be concentrating today on some of those techniques and methods. Before I proceed to the methodology, we might look first for a minute at the rationale underlying the concept of immunity for public authorities. Numerous decisions over the years have reflected a judicial tendency to find special circumstances, special tests, and special reasoning in determining the common law limits of liability of public authorities. Why is this? I suppose a useful starting point might be the recent English House of Lords decision in Anne's and the Merton London Borough Council. Lord Wilberforce, in his judgment, made the following statement: "The public body should not be liable when the alleged negligence attacks a conscious choice as to the use of scarce resources, or a deliberate balancing of thrift and efficiency, or when it results from a risk consciously taken by that body to achieve a policy pursuant to a discretionary power in a statute." In the Dutton and Bogner-Regas case, Lord Denning hones in on the underlying rationale as well by asking the following questions. If liability were imposed on the council, and I should tell you that was a case involving a building inspector who failed to observe that a house was being constructed on the site of an old rubbish tip, and in the result there was a substantial subsiding of the ground and damage to the house, and a claim was made by the owner against the municipality. Lord Denning asked the following questions. If liability were imposed on the council, would it have an adverse effect on their work? Would it mean that council would not inspect at all, rather than risk liability for inspecting badly? Would it mean that inspectors would be harassed in their work or be subject to baseless charges? Would it mean that they would be extra cautious and hold up work unnecessarily? In that case, Lord Denning went on, as you may know, to answer those questions in the negative. The point of those questions, and I suggest of Lord Wilberforce's statement, is that there is an underlying rationale that public authorities should be permitted the flexibility to make policy decisions in an atmosphere of immunity, knowing that when they balance thrift and efficiency, when they balance scarce resources, they will be protected to some extent. Now, in his forthcoming article on the topic of negligence in municipalities, Professor McCouch questions this particular rationale and suggests that it is very vague and doesn't really assist us in defining the parameters of public authority liability for negligence. I think there's a measure of accuracy in that, but I leave that with you as the rationale, and perhaps we can proceed now to look at some of the methods. I guess it's probably one of the first things we learn in law school is not to open an argument with a public policy approach. And certainly when we examine the cases in these areas, there are not very many which overtly refer to such public policy or public interest concepts. Lord Wilberforce and Lord Denning are a couple of examples where that criterion is examined, but most of the cases don't examine it overtly. And I think there are a couple of reasons. First of all, as Professor McCouch points out, it's vague, it's amorphous, and secondly, and importantly, there are a host of methods and tools, which I'm now coming to, through which the court can achieve the public policy result, albeit disguising it in these other methods. Now, in grappling with public authority liability, the courts have adopted these tools of decision, which I will call case knives. A case knife is a tool or method used by a court for arriving at a result to which it is predisposed. Now, if you'll permit me a literary digression, the term case knife has an interesting history in legal literary circles. I first came across it in Barry Ryder and John Swan's casebook on contracts. They had lifted it from Milner's casebook on contracts. He had lifted it from Pound's book published in 1910 called Law in Books and Law in Action. And Pound, in turn, had taken it from Mark Twain's The Adventures of Tom Sawyer. So let's look at some of the case knives or methods that the courts use in providing immunity or in denying immunity to public authorities. The first case knife is the distinction between legislative or quasi-judicial acts on the one hand and administrative acts on the other. This case knife is demonstrated in the Wellbridge case in the Supreme Court of Canada. You'll find the reasons of Mr. Justice Laskin, as he then was, interesting in that respect. But I propose to deal now with a more recent case, which cites the Wellbridge case, but which was heard in the Alberta High Court. It's the case of Bowen and the City of Edmonton. In that case, the plaintiff purchased property in an undeveloped subdivision. The intention of the plaintiff was to build a residence on the property, and prior to his purchase, the municipality had passed a resolution approving the subdivision, notwithstanding that the municipality had in its possession certain evidence which would give them cause for concern about the stability of the soil. In fact, the soil was particularly unstable, and the plaintiff was unable to build. He brought an action against the municipality for negligently passing that resolution approving of the subdivision. The finding of the Alberta Supreme Court is interesting because on the one hand they find negligence, and on the other hand they deny liability. Let me take you through some of the reasons of Mr. Justice Clement in that case. The city cannot insulate itself from the fault of its own commissioners, nor can it, in my opinion, as an improving authority, find shelter behind its municipal planning commission in a matter of grave concern which has been forcefully brought directly to its attention, and which the commission had also failed to consider as disclosed by the minutes of its proceedings. I am of the view that the city was negligent in ignoring the matter of soil instability when such ought reasonably to have been of concern in considering approval of the replotting or subdividing scheme. It remains to examine the nature of the negligence and whether it gives rise to a cause of action by the plaintiffs. And he goes on after discussing the Wellbridge case and says, "It is true that the negligent omission which I have found against the city rests on a different duty of care, but I do not think that this can serve as a valid distinction. Here the omission, and I emphasize this, here the omission was ancillary to the exercise of a quasi-judicial function. I do not think that the resolution of the City Council, followed by the registration of the plan, amounted to an actionable representation that the city had given adequate consideration to all of the matters which subdivision planning is directed, including soil instability." So on the one hand, negligence, yes, and omission. On the other hand, it's a quasi-judicial function that's being exercised, accordingly, no liability. Now, the second case knife I'm going to turn to, and I should say that the second case knife is very similar to the first. In fact, the first case knife we find in numerous decisions appearing in different disguises. Second case knife, which has come up through the American authorities, distinguishes planning or policy decisions from operational decisions. And if we look back at the Bowen case and the distinction between quasi-judicial and administrative acts, I'm not sure that there is a difference between what courts refer to as administrative acts and operational acts, but there may be a subtle distinction between policy and planning decisions and what courts refer to as quasi-judicial decisions or legislative acts. I suppose that, and in fact some writers have pointed out, that every decision at any level of government or of a public authority involves some element of planning. And this is one of the difficulties we run into with this next case knife. This case knife, as the previous one, has been utilized by the Supreme Court of Canada. In the Barrett case, which was a decision, 1980 Supreme Court of Canada, following upon a British Columbia Court of Appeal reversal of the trial finding. In that case, the plaintiff was injured when he fell from his bicycle after striking a pothole in the road. He commenced an action against the municipality on the basis that the municipality was negligent in not having a continuous inspection function in respect of its roads. The trial judge found that although the municipality did have a well-organized inspecting function, it should have had a continuous inspection, and as a result, the municipality was found to be liable. The British Columbia Court of Appeal reversed the trial decision. They found that the decision of the municipality in respect of the type of inspection that was going to be performed was a policy decision, and it was not up to the courts to second-guess that sort of decision, particularly, again, where it was a decision, and we come back to our rationale, which involved the balancing of scarce resources. And the Supreme Court of Canada upheld the decision of the Court of Appeal. As I mentioned, this distinction is of particular weight in the American authorities, and in the lecture in written form, which will be distributed later, you'll find several references to American authorities on that case knife. Now, the next method I'd like to look at, in a sense, flows from this distinction between policy and operational types of decision. It addresses what happens when a public authority makes a policy decision which in effect is no policy at all, which is an abdication of its obligation to make a policy. This was addressed recently in the Ontario Court of Appeal in the Dorshell and City of Cambridge case. Now, in that case, the plaintiff fell and was injured when she slipped on a sidewalk in the defendant municipality. The evidence showed that ice had formed on the sidewalk earlier in the morning, and the fall occurred approximately 9 a.m. The sidewalk had not been salted or treated in any way. The municipality had a policy of doing nothing about ice and snow on its sidewalks. Now, under the Municipal Act, municipalities are sheltered in respect of such slip and fall cases involving snow and ice, except in cases of gross negligence. The plaintiff's action then against the municipality was dismissed at trial, but the Ontario Court of Appeal found that evidence that a municipality has no policy or a policy not to perform its duty to ensure the safety of its citizens from snow and ice suggested serious and, in fact, gross negligence. I suggest that this is a significant decision because it responds to the situation in which the public authority has turned its mind directly to the issue and developed a policy which is deficient. In this case, it was a policy to do nothing. The conclusion is that it's no longer sufficient to simply say that all policy decisions will be immunized and not subject to scrutiny. The neat question remains, however, what if the municipality in this case had adopted a policy which was something more than doing nothing, but something less than a reasonable or consistent approach, a very minimalist policy? Now, it's not clear where the Ontario Court of Appeal would go in those circumstances, but I suggest they might well take the next step and find liability in that case as well. The next case knife I'd like to look at also deals with policy decisions and a particular aspect of policy decisions, namely the timing of implementing the policy decision. And we're going to look at a couple of cases in which we find diametrically opposed results. The first case is another decision of the British Columbia Court of Appeal, 1981 Mallet case, M-A-L-A-T. Now, in that case, the Department of Highways in British Columbia was responsible for constructing a median on a well-traveled highway. The median constructed in the early 60s or late 50s was 18 inches in height and was substantially less than would be necessary to stop a vehicle from crossing the median and going into oncoming traffic. In fact, as early as the 1960s, mid-1960s, the Department of Highways had information about a better and more efficient median which would prevent that type of accident from happening. In fact, then in the 1970s, and I believe in early 1974, the Department of Highways adopted a policy to replace the lower medians with the higher medians. Before that policy could be implemented, a number of months expired, and the accident in question took place exactly as one might have anticipated. A car crossed the median and rammed head-on into the plaintiff's vehicle. The plaintiff sued, among others, the Department of Highways, Her Majesty the Queen, and the right of the province of British Columbia. Now, the British Columbia Court of Appeal held that while the Department of Highways was not under a statutory duty to repair the highway, once the policy decision was made to undertake the installation of the 30-inch or higher barrier or median, a duty arose, and it was necessary that the district engineers in implementing that policy decision do so with reasonable care and within a reasonable time. So here we have a decision which might be characterized as a policy decision. That is, when are we going to implement this policy? They took too long, the length of time was unreasonable, that aspect of the decision was unreasonable, and liability was found. Now, in Mallet, the Court of Appeal took special pains to characterize that decision as an operational or administrative decision. But I suggest to you that that reflects a straining on the part of the court to categorize the decision in order to justify the ultimate result in that case. Now, in a much earlier case in the English Court of Appeal, we find the same kind of question addressed with the opposite result achieved. The case is East Suffolk Rivers Catchment Board and Kent. It's a 1941 English Court of Appeals decision. In that case, a farmer had a dairy farm adjacent to the tidal portion of a river. There was a seawall adjacent to his property and protecting his property from the waters. During an unusually high tide, a breach occurred in the seawall, and the water flowed onto his land, creating substantial flooding. Now, the municipal authority in that case undertook to repair the seawall. The evidence disclosed that that repair should have taken 2 weeks. Unfortunately, the municipal authority took 178 days to repair the wall, and there was consequently substantial loss to the farmer's economic position, and he lost his pasture land for that additional period of time. Very similar fact situation to the Mallet case, and yet the English Court of Appeal, Lord Romer, made the following finding. My lords, it has been laid down time and again that in exercising a power that has been conferred upon it, a statutory authority is under an obligation not thereby to inflict upon others any damage that may be avoided by reasonable care. But I know of no authority for the proposition that in selecting the time within which, the extent to which, and the method by which its statutory power is to be exercised, it owes any duty whatsoever. And in East Suffolk, the court ruled that the municipality was not liable. Now, to this point, I've looked at 4 case knives. First, distinguished legislative or quasi-judicial decisions from administrative decisions. The second, distinguished policy and planning decisions from operational decisions. And the third and fourth both flowed from the second. The third deals with policies which are themselves inadequate, and the fourth also policies which are inadequate but in a particular way, that is, in respect of the timing of their implementations. Now, all of these, I suppose, are variations on the same theme. If a court is inclined to deny liability, it will characterize the decision as a policy decision, as a quasi-judicial decision. If it's inclined to give a remedy, it will characterize the decision as operational or administrative. There are other case knives that I'd like to look at briefly. We look at several more in the printed materials. I'm going to look at just a couple at this time. The next case knife is causation. Now, from time to time, courts have founded a decision against public authority liability on an issue of causation. If the court can find a more direct cause of damage to the plaintiff, the court will refrain from holding the public authority liable. An interesting example of this occurred in the Ontario High Court case of Neabel, Neabel, versus the town of Ingersoll. It's 1967. In that case, the plaintiff sought to recover damages resulting from faulty construction of a building on the grounds that the local building inspector had failed to enforce the building bylaw and the building standards contained therein. The evidence indicated that the beams and columns installed were not properly centered upon the walls and did not bear on adequate supports. Ultimately, there was a severe cracking in the interior walls. The building was closed down and its occupants removed until the defects in workmanship had been remedied. Now, in a similar fashion to the Bowen case, Mr. Justice Stark in Nebel gives the following statement in his reasons. It is true that the building inspector was in default in not requiring the filing of adequate plans and specifications in advance, but it is not at all clear that this failure to provide such plans and specifications was the direct cause of the damage which ensued. So the failure to require the plans was at best an indirect cause. It was one step removed from the loss, and that step, the court found, was sufficient to shelter the public authority in this case. Another interesting example of the use of causation as a mode or method of immunizing public authorities occurred in the East Suffolk case to which I've already referred. There, Viscount Simon, in his reasons, states, in order that the respondents should succeed in this action, it is necessary that they should establish not only that the appellants were wanting in care and skill when exercising their statutory powers, but that they inflicted injury and loss upon the respondents by their negligence. In the present case, the damage done by the flooding was not due to the exercise of the appellant's statutory powers at all. It was due to the forces of nature which the appellants, albeit unskillfully, were endeavoring to counteract. Now, I suggest to you that that really doesn't answer the issue. The issue in that case was the extended period of the flooding. The municipality had undertaken to repair the wall. They didn't do it. To simply go back and say that the causal force, the substantial cause in this case was a force of nature doesn't really answer the issue. And in fact, if you look at that case, you'll find Lord Atkin treating that problem in his dissent. The last case knife I'd like to look at is the distinction between misfeasance and nonfeasance. This was also a factor in the Nebel case, and Mr. Justice Stark said that the most that can be complained of here is nonfeasance on the part of the building inspector, and he cites the 1898 Supreme Court of Canada decision of City of Montreal and Mulcair that an action does not lie against a municipal corporation for damages in respect of mere nonfeasance, unless there has been a breach of some duty imposed by law upon the corporation. I have some difficulty with that finding. The concluding words, it seems to me, render that paragraph somewhat hollow. There's no action in negligence for misfeasance either, unless there's some duty which has been breached. So I'm not sure where he takes us with that. The case knife, the method of using misfeasance and nonfeasance as a further shelter to public authorities in cases of negligence has not been resorted to with frequency, but there certainly are other examples in the written materials which we'll distribute later. Now, there are other case knives as well. I don't intend to deal with them now. I'd like to try and summarize and see if we can find some common threads. Various academics have attempted this summarizing task with differing degrees, I would suggest, of success. Let's look at what a couple of them say. In his article in the Minnesota Law Review in 1956, Professor Davis summed up the topic this way: perhaps the line is not between those who plan and those who operate, for all do some planning, nor between those who exercise discretion and those who do not, for all do, nor between high-salaried and low-salaried employees, for the government should be liable for negligence of a cabinet officer driving a government car in government business, nor between manual and mental workers, nor between those who affect economic interests and those who affect physical results. The line must be located on the basis of a judgment about the propriety of making adjustments through the medium of damage suits. Well, he had a good start, but I'm not sure that that line really helps us a lot. Professor McCouch, in his forthcoming article, looks at it another way, and I suggest takes us a step closer to finding a common thread. He writes, "Perhaps the answer can be found by looking to the purpose of negligence law and of the institution of government itself. It is clear from Justice Learned Hand's formula with respect to negligence that there is an important element of economic efficiency in the exercise of court's judgment in negligence cases." He goes on to suggest that where there are standards against which conduct can be evaluated, the decision may move into what we have called the operational sphere. And he gives examples at the municipal level of decisions which are based upon provincial or national standards. Decisions respecting highway construction and design can be evaluated on accepted standards, as can decisions regarding sewage and waterworks construction. The building code and its enforcement can be judged on the basis of standards that have been virtually universally accepted and adopted. So he says where there are standards available to which we might resort for analogy, it is proper in those cases for the courts not to provide immunity to public authorities. And I suppose there are countless examples of the application of the law of negligence to public authorities who are providing these sorts of services which have some analogy in the private sector or elsewhere in the public sector. More difficulty would be encountered in cases which involve exclusively governmental functions, such as the governance of prisons, building regulation, and the dissemination of rules respecting zoning. I have some difficulty even with Professor McCouch's concept of looking for standards and looking for a private analogy. I would suggest to you that in the 1970s and the 1980s, as we move into an era of deregulation, for the first time we are seeing government cutbacks, we are seeing deregulation, if not already, I would suggest in coming years, in respect of safety standards. Now, if there is, in fact, an erosion in standards, I'm not sure that the concept of analogy to standards will be extremely helpful down the road. I think that if a public authority makes a conscious policy decision, again based on the balancing of scarce resources, to diminish a standard which was previously held in the jurisdiction of that public authority, that will be a decision which will be given immunity, notwithstanding that analogizing to another community, we might find a standard which was higher. So I think we come full circle back to the three areas I suggested at the outset. The fundamental hurdles to any action against a public authority are these three. First, you've got to start by an analysis of any procedural limitations which might face your client. The next step is to examine relevant legislation to find any substantive statutory limitations. And finally, look to the common law. And when you're looking at the common law, I think you'll find 10 or more diffuse areas or case knives, any one of which may prove fatal to your client's claim. Each of them should be examined in the context of the facts of your client's case. Thank you.